the discerning spirit to discern between truth and falsehood. And we continue to ask that you grant the populace, the diaspora, and the international community, grant them the extraordinary patience to allow the due process to take its proper course. And you, being the just judge, will reward each and everyone accordingly. We ask through Christ our Lord. Amen.
Amen. Thank you very much, Bishop Odeko. Council, I believe we are continuing with our focus on the justice sector institutions. If that is the case, and you're ready with the witness this morning, you may please proceed.
Good morning, Mr. Chairman, and good morning, commissioners and members of the audience. Yes, we are ready to proceed with our next witness, and we are continuing with the justice sector reforms today. Thank you.
Thank you.
I, Borry S. Touray,
I, Borry S. Touray,
do swear that
do swear
I'll speak the truth,
that I will speak the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Good morning, Mr. Touray.
Good morning, everyone.
Sama, Mr. Touray.
Good morning, Isama.
Isama.
Isama, alhamdulillah. Good morning, commissioners. And good morning, members of the TRRC.
Alisama Commissioner Alisama TRRC Nkolu.
Thank you very much, Mr. Touray. I have the singular pleasure of welcoming my learned senior today before the commission.
Thank you so much.
Inumbara.
We thank you for honoring our invitation at very short notice.
Mbe numbara la nge kumandi wati sutun kono enate danku.
I'm grateful indeed.
And I also have the unusual opportunity and privilege to guide Mr. Touray, who is my learned senior, in his testimony.
And hanin kabi nyin ketanye site sewoti ame alonko aman dari kake puru ngatambi na nyaronko nyaro puru me alonko loya la karola puru ka tete nyi sedandro nyin kon.
I'm grateful indeed.
Aketanye nyabote.
Please make yourself comfortable.
Me danila efansindi efansoro.
Okay, thank you so much.
And during the course of your testimony, keep in mind that we have interpretations going on in the background.
Me hakilo bulanda fanan sedandro nyi wicho nyin kono kana soro be kering sansan kono jana nim bantala puru isi hakilo tuwaro.
I'm grateful indeed.
Aketanye nyabote.
In your testimony today,
sedandro kono bi
we would like to hear about your experience as a magistrate.
Belef la purka moy fan bulu tumala menna emu kiti telade dumalankoti ba fala me magistrate.
You were a former magistrate just after the military government took over in 1994.
Iketa kiti telade ba fala me magistrate tariyaren ke kabrin mansakunda fala ngera memu tuta in 1994 kudade bodala.
Focusing more on political interference into the judiciary.
Andung be nyatil na mbake men kono wala ngindi ko politiko la karola ke dabula judiciary men kere kiti bundal la fannati.
by way of executive directives, intimidation,
andunga ka nyame wala nyidde ko kangole ka bonan santo wala mansakunda la santo la bala multi kana ke dabula ko nyin kono
show of power and force, and other undue influence,
min yalon ko e kana semboning anin ka kangota mandi
consequently resulting in human rights violations.
min nata na nyala banke hanama di nyanta tinyala ko nyin kono.
And in doing so, we will explore the following areas.
Dun kawo ke mbelafla nyim fannal lel kachala.
We would like you to tell us if you know or if you have experience on how JAME used the judiciary and other justice sector institutions
Belafla ya fanyi ninga ya tara ya long ya jamme aka tilingo bunda aka ndabula je nyadi le anung aka tamandi dun nyadi le purka ala kango tamandi je.
such as the Ministry of Justice,
Abe kono ministry me mare luwa lin kirindir kunyala
the Gambia Police Force,
na polisi kunda
the Prisons Department,
na kasabunda
to achieve his own personal agenda
nyin kamala ate fango ate hamen ko mendiron purka o timmandi
and thereby perpetuate and entrench himself in power.
Nyin kamala puru asate ate le sembor ron ate system me sembor nyame purka fan ka supura sulo dun sembor.
How JAME used punitive laws
Jamme munafan ni luwa kurungol la nyadi le
to persecute his political opponents, critics,
puruka adonyol me alonko wala ma jawol ti ala mira lo puruka wol kitindi ke dete
and other perceived threats to his administration and power.
anu ngatele jikoro wala nyindi dolbe kala maslangol ti ala semboto anen ala maraloto.
And how people were routinely, falsely, and maliciously prosecuted under the criminal code using such laws.
Anu akeno ta nyadi le mol me alonko igana tuniro le kan fania kono me alonko anen tilim manta purke kitindi tilim baliya kan menni luwa manta luwal koto luwa kurungol koto.
We would also like to know about the abuse of the Ministry of Justice
Anin kabi mbela fla fanan ka alon ministry member ni luwal ni kitindir kunya la lana tambol me alonko wala kete la fannala.
in particular the manipulation of the Office of the Director of Public Prosecutions, DPP,
Andu abe kono wolem director me alon ko wolem marlin kitindir lal bela nyaton ko mebe ministry me marlin walin kitindir kunyala me alon ko ika yelamandi ila kul yelamandi nyamen ka kenyala me alon ko wole bate ala diani ko ti kawti mandi
in order to target political opponents
ingamale isaja ala jikoro menu matela opposition wolti pour kawul dalin kaw kulawol kan
through politically motivated prosecutions on bogus charges.
Andu kaka nyame wolem nyindi ko ka politika tumiro la mol kan rom politiko la karole isaje nyin kamala telafta menaron pour kaw timmandi atela karola.
After you became a magistrate, you went into private practice and you have extensive experience as well.
Biringi kibota kake kitindir lati dumalanga kitindir la ba forme magisterial na e ura ikitata na to do ko ke ifaye andum ila do ko nyin kono e londi sahari ngosota do ko nyin kono le
on some of the criminal and civil cases that you took for clients.
Andung ika kesi dol men dame alon ko dammani damma kesi dol modi ba forme civil matters dol be je on kuriya kesi dol de ka forme criminal yewta kilianol toyala
in which you witnessed human rights violations as well during those cases.
Damente yalon ko ila o kesi dol me alon ko yeta ila kilianol toyala ya hanabadi nyanta tinyal men je ku kol kono iso fanam fo.
So we would look at perhaps imposition of unrealistic bail conditions, for example.
And hani kabi fanamba fanna do jubela memo bail la karola ti me alon ko abukata ni tilingola silola.
And the blatant disregard for established, court and legal procedure.
And then wolem nyala fana me alon ko ka nyala kaso ke pour ka court la loi sirol ni sartol lande nyamen ke nya kaso la katani sila dola do fana jubela.
You also have extensive experience dealing with land matters.
And you londo fanan soto wala nyin kene nyin damma kene fitinol fana me alon ko wala ka dum molda malte ma yelondo soto fanan ko to bakele
from the district tribunal all the way up to the Supreme Court.
Abon na yin sefu kiti bundal do kata fo kiti bumbala sandon ko to mika me Supreme Court.
If you have any examples of how the office of the sheriff at the High Court was interfered with and manipulated.
Ninga etara yelondo so do bundala me alon ka be kiti ndir bunda do ba fala me sheriff division me yalon ko wolle be katara marale ninga etara kiti e kunturo ke kula me yalon ko tamandiro nyana kelo bundar men ka ko nyin tamandi ninga etara londi so foro ko ikay muna fa office o fana na nyame pour ka sembola mul kan.
especially in relation to the sale of forfeited property for the benefit of Jame.
Surtout abe ko ning ayatra kito e kundro ke ko kula me alon ko nyim dingira kar nyanna wafila le me alon ko sobobe je ko yaya jamme ay sulo sura ko nyin kono.
Bribery of judges and witnesses to secure criminal convictions.
Aninka jojol ta wolem kiti bunda sandon ko kiti la sandon ko de keta ke duko aninka kisedol ta fananka kudum ida kono waranto ka fendila pour yana kuma fo me alon ko be diala mansaye.
And the removal of public officials who were no longer in the good books of Jame.
Jamala do kulal fana memo masakunda do kulal te ke bondi la do ku palasol to nyin kamala ko ini yaya Jame mandra ni fanna keling mirodo.
We also have politically motivated constitutional amendments to entrench Jame in power.
Ko hannin kabi fanan loi buku bani fanan kono nga je fanan je ko falen dodol keta jele me yalon ko ya ke dalilo men kam wala nyindi ko pour ya Jame ron ata dianye ko nyin pour ka o se ka o timmandi ron ay o falen dol men keta buku nyin kono.
And this is just a guide.
However,
if you have other examples how the justice sector institutions were used by Jame, to achieve his objectives, we will be interested to know from you. Thank you very much, Mr. Touray. If you're ready to begin, we will start your testimony.
I'm grateful indeed.
Kindly provide your full name to the commission.
My name's Borry S. Touray.
Borry S. Touray.
What is your address?
I live in Farato village.
And what is your occupation?
I'm a barrister and solicitor of the Supreme Court of the Gambia.
And what is the name of your chambers?
My chambers is called Crown Chambers.
And where is it situated?
It's situated in Banjul at the junction of New Primate Street and Boxbar Road.
New Primate Street in Boxbar Road la sila kumbengoto.
Mr. Touray, you're a very experienced and senior lawyer at the bar. Can you tell us how many years post-call?
Mr. Touray, ita mumolde me alonko yelondo soto andung imeta lawyer len kafuba nyin kono le faisa fono nye sanji jelle tarta nyin doku wol kono.
I have 21 years post-call at the Gambian bar.
Na sanji mwanin klinike doku la bringa dati Gambia la kiti bundala.
Kindly give us a bit of your educational background.
Silang ila londo nyi kala karango nyi ya damura nyameng afanya bang.
Did my primary schooling in Sinchu Njabo Primary School.
Ngana primary karang ke Sinchu Njabo primary karang moleto.
In the North Bank region.
Bekerwan tundo le kang.
Sabah Sanjal district.
Sabah Sanjal Banko kang.
I sat to the common entrance in 1982.
1982 sang kono long alundi kontiboke ikafume common entrance.
Then I proceeded to Nusrat High School.
Nusrat High School.
I spent 5 years, 82, 87 in Nusrat. After writing to the O levels, I proceeded to St. Augustine's to do my sixth form.
O level londi kontiboke ntara St. Augustine's kata na sixth form kije.
I completed in 1989.
Ngo bang 1989 sangokono.
I worked briefly as a teacher in Nusrat.
Now, what is tunke karandirola Nusrat karambungoto?
For 1 academic year.
Sanji kilingo leke wa karandirola.
And I also worked as a field officer in the Women's Bureau in the Office of the President for a month.
Na karkilindo ko fananke musola office bala doku bundala me yalonko. Welle kata bantala kaduko leke dinkirato kaflamene field office and wotumo jebe president wala office wala koto.
Then I proceeded to Free College, University of Sierra Leone. A 4-year degree program to do LLB.
Ntata furabe college me alonka be Sierra Leone ntata na LLB ke wolto sanjinani.
I did my bar in 1995.
Nganna ba karango ke 1995 sankono.
That was my last exams in my life, and I failed that one.
wala mun na londi konti bo labango tinna baluwo kono bari wode manga nyede mboytale.
I came down home. I got appointed in the government public service as a magistrate, first class magistrate.
Seytana mbari nata do ko soto mansabunda la nketa magistrate fana mu kitindirlalti ikafome first class womu alodu la fololete.
Can you tell us what that means to be a first class magistrate?
So fono nyama okoto mo munete ni ko inara na Gambia bango kanya inara na do ko so man sakunda koto ke first class magistrate okoto mo munete.
The magisterial bench was divided into three categories. You have the professionals who would be trained lawyers or who would have had their first degree, LLB.
Ya tala din kira sabalete o kitindir bunda folo wala nyinti men ya lonko ye karandi han fo ye makamatake men ya lonko ye karanta fo ye LLB soto wolmu anola leti.
And then you have the second class magistrates.
Ye fanna fulanya soto e kafo men ye second class magistrate wala kitindir la bunda la lodu la fulanyangoti.
People who basically were retired and had a high degree of experience in the public service.
Wala moluti men ya lonko ye do ko ke bari na tay daha bari bitu ye londi saharing londi kono fa dum rim ba soto do ko nyi sambo la karola.
And third class magistrates, these are ordinary lay people who can be mobilized and then appointed to handle matters.
Nda sabanjango wala moluti men ya lonko manke ko ye karambake ka londi bal soto bari mollemu menu la ko faramansata isita yolu fanalu londi o bunda to men ya lonko si jube oke tilingu nin to nya sambo la kito la karola.
And then in 1998, I went back to Sierra Leone to do my bar again for the second time.
1998 muruta Sierra Leone nyin silo katanna ba sayin kanke kote ke sinya fulanjaw.
Mr. Touray, before you move on to Sierra Leone, I just wanted you to give us the difference between the roles of the first class, second class, and third class magistrates.
Mr. Touray, janne be ta ka kuma fonye ila murunga sinya fulanya kata Sierra Leone lafta ka ya fonye wala mun fatam fansila be nyim first class, second class, third class magistrate muna be tema.
When you are a first class magistrate, you can exercise all the powers vested in the magisterial court system.
Nimu first class wala makama folo nyinti woto sembe wo sembe nabe wo kiti bundala istesi o tamandinole ila do ko nyin sambola karola.
And in terms of the differences in their civil jurisdiction, first class magistrates can handle matters to the tune of $1 million, claims up to the tune of $1 million.
Between first class magistrate palastio fanalu kito lulanya anin kolu kafute manyaming isi kito lutano le anin kubo nyoto me ya lonko nin dépense bakono wala kodi kubakono men sita han for $1 million killing itelisio wo sarto lutano le.
Second class up to the tune of $750,000.
Second class wala mlu la flanja unyenti wolu isi menu tano ning misali kama kodi ko bakono men sita han for $1 wuli tawra wala nyong.
And third class up to the tune of $500,000.
Unda sabanjango nying wala men ya lonko isi kuta mandino ning la karolem men sita han for $1 wuli tallu nyong.
And I must also add that in the whole of the Commonwealth, the jurisdiction of magistrates, magistrate court in Gambia is the widest in the entire Commonwealth.
Commonwealth tundo mume obekang kolu lanya ntela Gambia tale kono fanuta bunda dolu taluti men ya lonko bebe Commonwealth koto.
Especially in terms of the exercise of criminal jurisdiction.
Sako kolu menu tilinta kruya kolu bonyoto la ninga kito lutamando.
Magistrates in this country can hear capital offenses.
Magistrate lu menu be nyimbanko kang isi kitindiru kunton kolu beta nole men ya lonko wolem kukurungulu kunton koti.
And Mr. Touray, that would be the first class magistrates in
First
particular.
class magistrates.
First class magistrate.
When first class magistrate woliti menu be lodu la follow nyinto.
Because they had the power and the jurisdiction to hear more complex and serious matters than the second and third class.
That's right.
And loi silo dila le pour ka kesi falta men ya lon ko kolayata le.
Abe onyale.
But just to be clear, during the time that you were appointed as a first-class magistrate, you still had not sat to the bar.
But hanka be purja yesene yadron kabri yeta tombon keke first class magistrate hanka be email back follow.
I did my bar in 1995.
Nanna back in 1995 samale kono.
It was because of me failing my exams in 1995. Why? I had to come home to work on the bench in order to prepare myself for the
Wiring-
second session, for
Now-
second sitting of the bar.
ngawo ba londi konti bo folo menke wayri mboytele manganye ngwakilta nseita nang nata bencho to wala na kitindirla la si lolula pour nyin kamala ngam fam parendi kotake pour nyaton ton sina akono masata.
And I
Just
must
want-
also,
Sorry, Mr. Touray, for interrupting you. I just wanted to bring out the point that at that time, there was no requirement for you to sit to the bar as it is the case now.
yes, you are perfectly right.
Council kay watembo amanke ni mukuti men kaninta pour ka kolu tamande men sike londi konti bodi bakaro la ko sayinga be nyami fatatale.
Kindly
Sedo
continue.
Kotonya.
My apologies for interrupting.
I'm grateful. Then like I indicated, I did my bar in 1990. I went for my bar second time in 1998.
Bitun nata muru katana ba nyin no masata memo asinya flanja ngoti 1998 sangokono.
We were interrupted by the events in Sierra Leone because of the civil war.
Bitun kolu nata na karango elandi ka kuntu katu tumo damma kelo wulita Sierra Leone banko kan.
However, we completed the course, and in 2000, I was enrolled at the Gambian bar.
Baro nyawnyandi nga katangal na karango to labang bitun hanfon seitana nata na dung Gambia ba kitindir bundala
And
2000 sangokono.
I still continued service on the bench.
Bitun hanim bin continue ta do ko la bundala ka fudam ye bench wala menumu kitindir la silalu tije.
And over the period, I had a couple of training on human rights because I was a member of Amnesty International.
Bitu wo wuce okono nata karan londi karan fason fula soto me ya lonko aben adenta hadamaya nyanta kunya lela katu wotu mombe ka fokono ka fo me Amnesty International.
Gender was also part of my training.
Musunin ke tema fatam fansolu fanaluda ben na karango konole.
We also did a course in Sharia.
Andu londi karango fananke saria kitindir kunyal tole.
That's my professional and academic background.
Wala mo na londo silolu ni makamu luti ngamen no soto karango ni londo la karola.
In terms of your experience as a private legal practitioner, in the
Londo
Gambia,
remen zoto ka ke moti me alon ko be lori fayen ka lo mole kitindiro ka vanala.
where would you say your expertise lies, or what kind of cases would you normally involve yourself with?
Iba fo ete ba fo ko fanna jumal mu fanna me alon ko ite nyatili wo fanna andu ite ka kesul jumal le so men so me alon ko wollel sembo warta andu ite ka nyatili ndo wollel o sifal.
Let me also say this, all baristas in this country are general practitioners.
Mbatu nganyim fanamfo makamo me ka fa barista men ya lonko do makamo to nyim banko kan wolu be mu ateo kitindir la kilingol leti.
There is no one particular chamber that specializes in any one aspect of the law in this country.
Amunta bunda lori ntije ka foko nyim bunda kari nyim wolu ka bula nyim londi kar le noma wala wolu ka nyim londi kar le kitindi wo bunda lu mansoto.
That's due mainly to the nature of the economy, small size of the population. But my practice over the years got concentrated on criminal and civil matters, more especially land.
Ujama katilim banko fanko Kenya lela aning banko la doya Kenya fanan kama. Bari bitu ntela kulu noma sato nkabula menu noma bake wala mnying kruya quality menu yalonko ikana finti ke iftandi kiti bundala.
Taking your career in chronological order, you started off as a magistrate, first class.
Ni ajube la londo nyi ila nyatili nyanyi kelanya purunga bulanyo no ma nyadi tilinda nyoye nyame ya follow dame do wala kitindir lati kafme magistrate.
Yes, that's true.
Umuto nyalti.
I would like us to explore the order of judicial interference.
Mbela fla purunga order fo senade do mande wala kiti bunda nyi na dabulo men kaka ko nyi do wato yobeje
By the executive into your work as a magistrate.
andu dabulo nyi kaka bo dame do wala msanton kolti man sakundala karola ila do ko nyi kono.
After you were first appointed as a magistrate, where were you posted to?
Bri ye tombon kuta ke kitindir la do malanko de ba fla me magistrate ye samba do ko la min dole.
I was posted in Banjul Magistrates Court.
Mbe Banjul Magistrate Court le nga follow jele.
At that time, who was the Chief Justice?
Wato la jumalam kitindir la be na nyaton koti.
The late Chief Justice Omar Al-Ghali.
Kala Chief Justice Omar Al-Ghali.
He was a Sierra Leonean by nationality.
Atemu Sierra Leone banko dingoleti.
May I apologize? Chief Justice Omotion.
Chief Justice Omosun.
Omosun was a Nigerian,
Omosun mu Nigerian oleti.
came here on technical assistance.
Na tajang nyinkam mapura e makoiro tamandi doku wala karola.
Algali came after him.
Algali bulata atelenoma.
Okay, but generally on the question of interference, may I divide the Jammeh era into two phases?
Bari niya jube mansala dabulo kito nin kitindir kuolu to mbela fla katalaka ke fanna fulati.
Mr. Touray, before we just go there, I just wanted to know some of the key players in the system, like who the DPP was and who your principal magistrate at Banjul was, just so that we can get that context and background before we move on.
Much obliged.
Principal jannim bida odo folam bela fla kalon folo jumal le mo molti men yalon ko wolle fam fam woda ba ko nyin kono misal fe bela fla kalon jumal principal magistrate jumal mun DPP di men yalon ko wala katara maralin masakunda la kitindirla la nyaton ko la o sifa la na nyongol bela fla ka wala lon folo jannim bida odo.
The principal magistrate in Banjul Magistrates Court was His Worship Magistrate Onya.
His Worship Magistrate Onya wole mu kunton kotinu wo kitindirla silolu la karola.
He is a Nigerian by nationality and a man of distinguished birth and a very strong character.
Ate mu Nigeria banku dinguleti mole fana mu me yalon ko atobota adu molem me yalon ko ala kolu ake bambandi bakele naba atamandila.
Was he also here on technical assistance?
Yes, he was. He came along with 3 of his colleagues.
Atena akafunyolu mo sabale na atanyola.
Magistrate Sadiq in Kanifing, he was the principal magistrate, and Inyang was in Basse. He was also a principal magistrate. They are all Nigerians.
Magistrate Sadiq member num Kanifing, and Magistrate Onyang wobenum Basse, bari telube na ta osilakili mo kan kitindro la karola banko kanjang.
At the material time, I believe it was the Attorney General was Mr. Marong.
And watembo nlata la ko tumo Attorney General moleti kafome Mr. Marong.
I'm not very sure about that, but I have a feeling that it was Mustafa Marong.
Amang ko imma baba bakere bari ngani miro soto ko tumo membi je kafa na Mustafa Marong.
This material time is what year?
This was 1995.
1995 sangola konote.
Yes.
I believe Mr. Fafambai was the first Attorney General.
Njikita Mr. Fafambai atela munu Attorney General.
Yes, that's right.
Umuto nyalti.
Masakunda falingo kera waro men.
Umuto nyalti.
So was this after he had been removed?
Kera waro men yata bondi bang.
I believe so.
I
didn't meet Mr. Mbai in the office.
Dama Mr. Mbai tara office.
Kindly tell us what your experience was at the Banjul Magistrates Court, working as a magistrate under Principal Magistrate Onya.
Silang afanya bang wato mena ita mukiti ndirla ti me alon ko do ko ke kam Principal Magistrate Onya koto. Muna ketete la kulti men yalon ko yolel karanga ko ni do ko nyin kono je.
Okay, let me go back to the 2 phases of division that I would categorize the Jammeh administration into.
Ngata nga ofana fulo memfo. Alhaka ko nga Jammeh la mararo wucheo kolu talanya mengake ofana fulo mende mbaranga muruje kan.
Yes, it's true. There was interference with the judiciary during the pure military era, that is during the transition of 2 years.
Wotumo sojar mararobe kering wuche falingo beke kantumo men usanji fulo kono.
But it was far less in degree than what later came to pervade after he had transformed himself into civilian administration.
But wotumo akuo mansia asembo fana mawara baba bake ko anata laban nyaming biring ay sojari abula ay faling anata ke civilian oti anata dum mararo kono wotembole mkolu wajabita.
The government, the executive then had very little interference with ordinary civil matters or ordinary criminal cases.
Wotembo ko fulodulato wotumo kunton konying ala makango doyata bakele kolu to men keta okuruya kolu bonyototi aning moni motema kitolu fanalu lanyato.
Their focus mainly was on matters involving senior security and police personnel. Senior security, army and police personnel who were arrested and detained, and some of whom were being prosecuted.
Wotembo itelanya tilinta kuomen wala mbrim falingu keta ye police kebalu menu mutani sojar kebalu wala kanto nin tankada bunda nyaton ko lumenu ye mutai be dolu kitindi kan wotumo itella nyatili nyaketa wolle la koltinu wotumo.
So first degree, my first experience in terms of interference was when the case of Inspector General of Police versus Pasala Jain, Ibrahim Chongan, and Keba Diba was assigned to my office.
Amunta ntela londi foro kuolu tamandi nyato dabulo la karola kitoto waketa watu ulti bring kito futatama Inspector General of Police Pasala Jain aning Ibrahim Chongan briwo lakko nata kafutama
And Keba Diba.
aning Keba Diba.
And Mr. Touray, just to give us some background before we go into that particular case, give us the context, especially with the passing of some of the military decrees at that time, what the effect of those decrees were on the laws of this country, especially the constitution, before we go into the facts of that particular case.
Mbita ko nyimbela nyaro sa mbela fra ya fonye janni kabri tara fo nyin bunda loi dundi ga fne decree wo decree nyin anata na mun kole ya kulel sabu ko nyin kono janni be constitution nyin londila.
When the Armed Forces Provisional Ruling Council was being created,
Biribe AFPRC lawo council bunda londila Armed Forces Provisional Ruling Council.
they promulgated Decree Number 1,
Ye certifolo dada ekafome ye degree number 1.
and that is the Armed Forces Provisional Ruling Council Establishment Decree.
Wolem sarto timmeye Armed Forces Provisional Ruling Council la sarto wole bunda fangolondi.
Sorry, may I apologize. The first decree was the Constitution of the Republic of the Gambia Suspension and Modification Decree Number 1.
Al haketu filo keta je decree follow nying wolem ye banko la sambarang sarti bukuba nyin ne fangola kolu follow falling we ka fole constitutional aning itali lafta kolu menu tamandila je.
By this decree, they suspended the whole of Chapter 4.
Bitu decree ya sama ayasabu constitutional la sapanani njangu mumeo be chapter 4 yo be denne.
And this is where you have the entrenched and protected rights conferred by the Constitution, fundamental human rights.
Adum mole mu bundati meye hadamaya nyantolu be londi ke bambandi me yalon ko wole ka hadamadingulu kanta ila baluwo kono amunta etelio bunda nyi mumeo bele demfolo.
So the junta gave itself power to arrest, detain anybody for any length of time.
Junta nyi ngolem sojar marabunda ye sembo di ifangolula iteli lafita momondi marala wala lafita momondi mutala isi muta ye sindi fojan ning wati mendiate tole nyawnyandi nyama.
Also, they arrogated to themselves the whole of corpus of the executive and the legislative power of the nation.
Bankola sembo kabirim mararo la karola fokuntonko fanan sembo la karola anin kata kito fanalu lanya bunda tukumu la karola yo sembo bechika ya di fangulula.
And Mr. Touray, sorry, just so that we can understand before we move on. So all of those protective safeguards that were in place during the criminal justice system for accused persons were no longer available to them at this time.
Amunta pour mo tumiri mo o mea lonko tumiri mo lem pour ka même loi men nyanna ka tankandi kan ka tankandi yolbe mu kulel mea lonko wolbe man raw tumiri mo ko tanke yolbe bondi jele ko.
Yes, that is right. You can no longer as a lawyer go to court and then file an application for the release of your client who perhaps has been arrested and detained.
How muto nyalti ni mu lawyer te wotembo fango ititano la kitibundala pour kata safero kije pour nimmo mutari ngobije mem muitela kliano te pour isio bula nyaming wotembo lawyer ma osembo soto.
The stage was set for imposition of dictatorship from the very beginning.
Amunta wotumo lem yelondiro ke kasulo dundi sartolula me yalonko wolle be tajreya aning sembela mararo londi la nyimbanko kan.
So there was no right to liberty per se, the right to bail, and the 72-hour time limit was also not applicable.
Wala mintigo hanamadi momam nyanto soro fay pour ka fansoro andung pour bail fanang na karola fanana na kolea ko nyinkono.
That's absolutely right. All notions of rights and freedoms were suspended.
Umuto nyalte bitu molla taram fambulo fansambo aning ila kolu Kenya mfayo yolu be kafunyo male utumo ye deng asembo te mola.
And what did that what effect did that have on the rights of accused persons especially if you try to juxtapose that with the case of IGP and Pasala Jeng and others.
Wonata na mun kolya kullel sabu o tumir molla misal fe surtout ni nata na sawndi yana misalo di IGP Pasala Jeng anado nyol la case nyinto.
May I give a bit of a background history here?
Please go ahead.
Before the case file was assigned to me, there was a lot of battle between the defense team and the prosecution team for the bail of the accused persons.
Janning kito fongo be dilantela nyo sababale tartaje nung kitindir lalu aning loya dolu tema menu be lori ngi muta moliye akete tema nyo sabale tinung karaning karatema janning kito nyimbe chikala kadintela.
And the trial magistrate Onya, who had conduct of the matter, ruled in favor of the prosecution, denying the accused persons right to bail.
Magistrate Onya me ya lon ko be laari ngatele bulu nung ay ñi sembo tamandi je ka balang pour ka ñi molu bel menu be loyal membe lori ñi moli nung amunta ayolu korindi jele amanson pour ñi molu han kiliye bel ikono.
And was that pursuant to decree number 1?
No, that was not pursuant to decree number 1, but other follow-up decrees.
Wo amanke ko be dendin decree follow ñin la de bari bitung decree dolu fanalu nata fintile men ya lon ko wolio dinkira bambandi.
In particular,
Sako membe ko
we have state security detention of armed and police personnel decree 1994. That's decree number 3.
Sako sarti sabanja umen inata afintindi 1994 men tilinta molu mutola menu be kantonin tankada bunda dokola wolem police men ko menu be security wala karola.
And I believe this particular decree affected these particular accused persons because they were military personnel.
Amunta mfele ko nyin decree ni kay men decree men nak mo foten anarna nyin tumi mol nyin batandi bakale me alon ko tanko bunda mol.
And their names were specifically, I believe, gazetted in the decree.
And we told you that they told you kuson leila in gazeto nyin to ka korosi.
That's quite right. Pasala was from the armed forces. He was later appointed as Inspector General of Police.
Umutu nyalti Pasala atabota kanto nintankada bundale la dunkokola ina atake Inspector General ti Police la karo.
Ibrahim Changan was a Gendarmerie officer and Keba Diba as well.
Ibrahim Chongan atanin Keba Diba itulbebe zanda bundale la nundokola utumo.
They were later transferred to the police when the Gendarmerie was being dismantled.
Ina tesa undi kenaiti police bring ibe zanda mbunda nyin janjan natumome.
So legally speaking, Magistrate Onya was right on the law as it was.
Ni biaju be woto Magistrate Onya abe tilindi nenunde lua be lari nu nyaming wotembola.
In refusing to grant them bail.
Purka balang nyimolu purke bail.
There was an application before the then Supreme Court, which is now the High Court, for bail.
Wotumo safero ketalunun the Supreme Court membe keri nu wotumo sa ingolem High Court ti pur bail ko la karola.
And the Supreme Court also upheld the position of the magistrate that he doesn't have jurisdiction to grant bail.
Adu bitung wo kiti bunda santon ko nata nyi londi magistrate la kango kang ko aman sembo soto purka bail di nyi molula.
So it was after all that skirmishes and after the transfer of Magistrate Onya from Banjul Magistrates Court to Kanifi Magistrates Court.
And we nata Magistrate Onya saundi kabundi Banjul Magistrate Court kasamba Kanifi Magistrates Court.
Because the state had intractable difficulty in getting decisions from his court going in their favor.
Puruka kangulu soto atela kiti bundala kangulu meni alonko wole mansa nyatonko mansa kunda fasa nungotumo.
They had to re-engage one lady by the name of Mrs. Scott, wife of former Liberian ambassador to the Gambia.
Inatamola makwero nyining Mrs. Scott meya lonko inatate dundikolo kono anduotumo Liberia bankola ambassador membe nyimbanko kangolela musomu marioti.
Mrs. Scott came here on technical assistance as a magistrate from Nigeria, and her maiden name was Miss Ogojafo.
Anatanu jam doko silo melna wolem kana makwero ke wodoko bundala bari abinatu mo melna utumo to men ka foye ka fole Ogojafo.
At the end of her term, she decided to stay on contract.
Bari birala doko keta hanfo awucheo banda ñinnata dunga fango kono prasi tujang ay continue do ko la bari o katarta contrat ko le kono.
Along the lines, he got married to the Liberian ambassador.
Bitum wo wucce o kono lem anata futu Liberia la ambassador e membe Gambia jangutumo.
And the Bar Association petitioned the executive that you cannot be a spouse of a head of mission designated to the country in question, and you be allowed to function in the public service of that country.
Bitum banata nyin safero ke ko te kenola ite kenola no monyoti moye me yalon ko mu ambassador le tin bankun kan wokola ite me mo mari la no monyoti yena o silo soto kaw maka mota pour kaw do ku façon ke banko kan ko te kenola.
At that point, can you remember who the president of the bar was?
I
did not join the legal system then. I was in the university.
Wotumo mantara lua bunda do kola otembode mbe university ol tunu wotumo.
But it must have been between Surahata Jane and Usain ONM Dabo.
Otembo abetarla mo fulale tema Surahata Jane wala Usain ONM Dabo.
So following this petition, Mrs. Scott was obliged to resign her position as magistrate.
Birinkiti bunda yo kanindiro ke yo safaroke bitu Mrs. Scott feremantu aije faye dahadu ko nyinna.
The Liberian ambassador became the dean of the diplomatic corps, and because of that, she had close personal interaction with the former First Lady Tutifal.
Bitu tumo Liberia la ambassador le natake ambassador dolu bela kunton koti banko kan ikafole dean bitu kamala alawo nomonyo anim banko president la nomonyo la kulu nata kata nyola foi futata nyoma wotembo madame Tutifal jamme wala be futu wala president.
I must also add that Mrs. Scott was a very highly vindictive person. She had a lot of difficulties with members of the private bar.
Mbenyim fanan la fala je ko Mrs. Scott wotembo mole me alonko bitung nyi kuolu ka kuolu noma sata julujo kan wakadia lumbake andu wale ya sabu aning kitindirla jamali kole ya kuosoto meni alonko ibe banyi na karola utumo.
So she got Tutifal to convince Jammeh that if she was reappointed as a magistrate on the bench, there would be difference in Banjul Magistrates Court. The state was going to get convictions in its favor.
Bari anata kata ay fero ke hanufo ay nyingani yoning hammo dundi akafunyo kono memu president la musoti wotumo madame Tutifal Jammeh pour wo sidia mu akemae nyinkanko ni ate murundi na wo kiti bundala mansa kunda ka kole ya kolu menu soto nung e wo kito la karola puruka ite langani ya kangolu tamandi akobe bolale ibe amunta mansaba angani yo soto na le kiti bundala utumo wala Banjul Magistrate Court kiti bundala.
So the junta reappointed her as principal magistrate.
Bitung sojar bunda na ta sainkanta aketa magistrate kunton koti principal magistrate
and forcibly transferred Onya from Banjul to Kanifing, and she was to take charge over all the sensitive case files that Onya was handling at the material time.
Bitu watembo ina ta Onya forceto saundi ka bondi Banjul ka samba Kanifing kiti bundala bitung atemeng ate ogojafo me ya nati je bitung silango tumo le ngabulo nata la failo lu ninkito lukang meni alonko magistrate Onya be wolle tamandi kanum bitung atenata si wolle kunna.
And would you agree, Mr. Touray, that that political appointment was a direct interference in the judicial system?
Certainly it was. It was.
Political karola ke dabula kiti bundal no mukula me alonko bantambil bukatra wotonu o watolan
ha wo mukule wo mubantambilo le fangoti ka o katenati ka dundina kiti bundal.
It was clearly a violation of the Geneva Convention on Diplomatic Privileges and Immunities.
Adu wo fango ay sarta dole tinya sarto me alonko dunia be kambenta wole la bunda bala ye melondi nun Geneva Switzerland banko kay ka fole ye Geneva Conventions nyin sarto be lorin woleto bari amunta itelate tombongo woyo sarto tinyale.
So when she came, there were so many files.
Birana file jamal le bijenu ngotumo.
Mr. Touray, I just wanted us to just go a little bit back and tell us what the source of this information was, the information about how she became politically appointed.
Mr. Touray selenga murko madomanding afanya bang nyin kibaro nyin aketa nyadi le akeno ra nyadi le fo inara na nyinta ya murundi do ko la politiko la karola politiko silo men da fo ya murundan kana do ko la kotake kake magistrate woti.
At that time, I was not very much connected to the establishment.
Yotembo man chokinyola bamandi musoto do ko bundala.
But Magistrate Onya, who was with me in Banjul Magistrates Court as the principal,
bari Magistrate Onya ni membe nyobala nung Banjul Magistrate Court ko atemukitindila nyaton koleti.
had a very close relationship with the Nigeria High Commission and with the Ministry of Justice.
Ay chokinyola sutune soto anin Nigeria la High Commission tema anin Banjul anin minto
The Attorney General's chambers.
Attorney General Office Onying.
So news that Mrs. Ogojafo was going to be appointed as a magistrate
Kafoko kibaro me yaitaniko Mrs. Ogojafo ba tombona le kake magistrate.
reached us well in advance of government taking a decision on that.
Wofuta tantelu majuna le hanijan nimman sakunda bafang akonying kela.
And how it was all generated, we also got the information.
Atamata nyameng akolu lata nyameng ngawoki baro lubeso to otumole hanijan na bekela.
Yes.
Thank you very much for that explanation. Kindly proceed.
So she then became seized of all these files, and then for some personal reasons, and that's by virtue of some relationship between herself and the former Inspector General of Police, Pasala Jang.
Bitung anatake moti memmarata o failo lubela anin kolu meni alonka yetaraje. Bar bitung fanan kolu lanya anatake nyintiko anin mola kolu takita nyola me alonko wala kita moti kafume num Pasala Jang,
who was accused number one in this particular case.
Me alonka telo mo tumirim folote nyinkito kono.
She had moral difficulty handling that file in particular.
Wo keta ya kole ya kote afango sondo mo miro la karola purka o failo tamandi.
And that was how the file was assigned to me to deal with it.
Wanyale ya sabu ye failo nyinchika inata dintela purunte nga tamandi.
But the government itself at the time was not aware of that decision.
Bari wotembo mansakunda fango mambo wo kango kalama ubetala tu momeng.
So when I was assigned the file, I went through it. I came to discover that there were 52 adjournments on record.
Biringa failo nyinta ndunta kono ngala kulu kesemeti. Ntata tarako sinya talulu nimfula ika kito nyimama ndi deng.
And on all those occasions, it was only on one day that a real trial started. That was when PW1, the first prosecution witness, was invited to commence his testimony.
Aduwo kita o sinya talulu nimfulo beka kito deng. Sinya kilinnamu ye konyin kito fango diamu andu wolungule lunti meya lonko sede folonyi nata finti kadiamu akonyin kono.
And what was the reason for all the other 51 adjournments?
Sa mo nan dalilo ba kan ka sabu me sabu fo nyin lung talul ning fulo be ka lungol sounding fa fota fo mo nan dalilo di.
There were many factors. One was applications relating to bail, adjournments, arguments. That was part of it.
Kujamale bedendinga la bari bitum bel kolu kito la dengo Kenya lo an India mulu membe dendinga la wulu bebe akonyin kono le wutumo.
But nothing of substance happened.
Nothing of substance.
Para manke kukumati.
So I then issued notices and gave a date for matter to be mentioned in court.
Bitungo tumole nata molu kala mutandiroke ane ngakango difanang lumeng akobe fola kiti bunda nyina.
Notices were served on both sides.
Nga kala mutandiro samba karafulo lubela.
And then we converged and we took a fixed hearing date.
Mbenta bitu tumole nata kambe nga lunguta lungmembe kala akuo lungo diamoti.
Now on this day in question, the state did not produce a witness.
Bitu lungumeng taonya lumeng komba akuo diamula bitu mansakunda mandan sede fintindi membe lola akuo kono.
Can you tell us who the prosecutor in that case was?
Sa fo na nyo case nyindo jumala mukiti ndirlati sakunda la karola.
He was Lamin AMS Jobate. He was then the Assistant Superintendent of Police in charge of prosecutions.
Wotumo Lamin Jobate lemu kitindirlati wotumo atelefona mu Assistant Superintendent Police la Karola amonda akonyen dunta atelebuloko no wotumo.
Is this the same Lamin Jobate that appeared here on the Trrc, previous Minister of
yes.
Justice?
Ate Lamin Jobate kilingole mbammen nata nyisira kanjebe dawo Trrc nyati ono nyakoma to ba.
He was a lawyer who was on secondment in the police force, and he was in charge of all prosecution matters.
Atelemu loyati yemenna do ko samba police la karola ndum kitindirolu be nyan natata atele la karola.
So when we converged to hear the matter, the state did not produce a witness.
Brimbenta purka ko ndiamu mansa kunda manna sede fintindi.
And we asked him what was the reason why they were not proceeding with the matter.
Na nyinin ka muna na itelu mantara tenten kan ko nyinna.
And we are not satisfied with the reasons that were advanced.
Adu itel nata dalilo lu menu fontele wolu manke dalilati meyentel nyafa.
Because majority of the witnesses were police officers working within the establishment.
Kadu mo jama membe itela o sedo lu kono menu fo wolu be mo police leti menu do ko la bunda nyim fangoto.
And most of them were in fact at the material time at the police headquarters in Banjul.
Adu tembo fango wolu jama bebe kono ibebe do ko la banyunu police korda ba nyim fangole to otumo.
So it was like taking the court to ransom.
Because
There was no justifiable excuse.
There was no justifiable reason. My personal impression was that because the case has continuously been adjourned, so that trend was going to continue. That was the prosecution attitude.
So what position did you take at that point?
The defense lawyers made an application for me to dismiss the case.
And
I can remember there were Miss Drame, Usman Silla, and the late Pap Jason Seka.
And by Ms. Drama, you refer to Ida Drama?
Yes.
Miss Drama, Madam Ida Drama.
So by the time Mr. Jabati realized that something momentous was taking place in court, it was almost late.
Mr. Jabati binajela kohe kukuma bale pareta kela kiti bundala baru utumu atela karola tardeta lebe.
So they thought I was going to adjourn the matter again for ruling. I insisted that I was going to deliver the ruling the same day.
Itelenye mutanunko mbe lundo le mutala kota ke lumme mbe kito nyintela. Bari mfana lota nyine kanko ulumu fangole mtebe kito nyinkela kate.
So I went into my chambers whilst I was writing my ruling.
Ntata na office okono mbelna kangolu safe kango tumo mbe kango mentala.
A whole truckload of soldiers were deployed in Banjul Magistrates Court.
Ye moto fa mumeole nati je wolunga bemu soja rolti ye nati Banjul Magistrate Court.
It was like a military camp.
Amunda wolunje bele ko sojar campo.
Some of them, in fact, entered right inside the courtroom under the roof of the court.
Jama fang sodon ta menu dunta nan kiti bunda fang nyin kono.
And were they armed?
They were all armed. All of them were armed. They were not, in fact, with riot gear. They came heavily armed.
Misal kama ningere wala keta wala balambaya ke fankanta jona wala mena ni wala manna itel nin kidol le nata
when they came combat ready.
Inatala ko molu menu pareta kelo.
It's like if you are deploying them to the battlefield.
Amonda inatala ko menu pareta tala kele wulo kono.
So when I entered the courtroom with my ruling, I asked all the soldiers to go out.
Bitunta nata dum kiti bundala ninna usarto lumenu ngesa fe nko soja rolu be finti banta.
They had no choice. They had to leave the courtroom.
And
I must also add that these three gentlemen went through a great deal of trauma. Because I observed for long when they used to escort them to court. Under the roof of the court. Wherever they are seated, the soldiers will be standing, pointing the nozzle of the gun against each one of them.
Kato haninyi molu be sirin daoda soja rolu kai baindi nan ka loy ikunto kiti bundala ando ngabukadang lo kunto la de e ka kidole fongo datli nyi molu lay be sirin dame.
But when the matter was assigned to me, that was the first thing I said I wasn't going to countenance.
biri ye ko sawndinte kan wala mu ku folotin kontete men jela malla fi wala.
Mr. Touray, that position taken by the military or by the government in sending armed soldiers to the court was, in effect, an attempt to intimidate you.
Woto Mr. Touray o masa kunda warando sojaro kundaro yo baro menketeng puru inaje ka sojaro kina je nin kidolu ina kidi bundaro o mu kula me alon ko inata la pur kete fanan ke silandi.
Yes, that was part of it, but also there was a security aspect of it because they were afraid that I was going to release them
O da
on that day.
Oda bijele de bari kanto karado fananda bije wala mindi ko sobeta ko asikeno ntenga nyimolu bula wolum fango ke bula ye fansoto.
And members of the family who were there too were prepared. If I was to discharge them, certainly there was going to be a big showdown between them and the security. People were just fed up.
Nyimolu fanala badi ngulu bije ila dimbaya lu bije andu wolum be pareri ngulu fanala be pareri nyina la ni ye bula abe kelama mambale tinunje wolum katwotumo molu fasita ifasita ko la ferengo tumo.
Were you intimidated?
Yes, silandi la baita fankunda.
Far from it.
Jamfata wala.
I drove them out of the courtroom and then I proceeded to deliver my ruling.
Baike fintindi kiti bunda kono alum nata tenten tanga kango menta ngawole kana fanam bankeje wolum.
Mr. Touray, I'm very interested to know why you were not intimidating under such circumstances. I think any reasonable person would have been. Can you tell us from where you drew such courage and boldness?
Well, Mr. Touray afanyeng muna keta dalilo tinung meye teju so bambandi aye hanyindi puru ka okota mandi wonyama wolum katu ni momondin dolu abekele kijate oleti fangi silang wo molu wo joranti olula na aje kama.
I think it's mainly because of my nature.
Ngamira follow ndanya wole muku followti nsiofo.
I hail from a very difficult father. He's not somebody anybody can easily intimidate.
Nde fama mu moleti me yalon ko ke kolembale mu adum purka silandi wo mu kuleti me yalon ko bukana mama ndifang mo buka silandi no.
And I remember the day I was appointed, I came home with my appointment letter. I showed him.
Lummen hakilo baka yen tombon ka nyindo ko dinna mbese la suwo kono tumo menna ninna letero nata nyola le tembondir letero me ya dinna nata mfutatama.
He asked me to sit down.
Akonyen nsita.
Said, this your work is different from every other type of work in the public service.
Akonye tela nyindo ko nindo ku dolu be fatata le mansa kunda do ko fanambe ebo kito tamandila wala nyama woto si haklo tu tukunguluto nibe kito nyinkela.
So he told me, don't ever be afraid of anybody in the system. Do what is right.
Akonye woto kana sila mo womondina nyin bundala nyin doku bundala karola mentilinta bulawo no madron yeto nyata mandi.
But quite apart from that also, I was in Sierra Leone and I've seen war from another dimension.
Adung hana manke o damanti mbenu Sierra Leone nyinkelo damu tata nyala jele mga kelo sede ya nyaya je kelo fanang na kulu koleata nyaming.
It's much more difficult to deal with the police than to deal with the army if only you understand their psychology.
A koleata puru inim poliso liye kudu nyotema wale koleata inin sojaro liye kudu nyotema natara ye la kulu tanya ning ila kulu lanya fanang koto long.
So I delivered my ruling and then I made an order that the accused persons be remanded in custody because that was an earlier decision by a previous magistrate and the High Court has affirmed that. I couldn't overturn the decision of the High Court as far as their release was concerned.
Baribiringa quota nganying kele koye bula baribitum ibe tulam remand le follow ko kiti bunda menu follow tante nyaje ko liya sarto landi nyaming yo adumu bunda le tentete men na kango bondi nola wala kela kango bayno wala nante fana ya landi wonya ko tuliya landi no nyaming.
What was your ruling?
I dismissed the case and then made an order for the accused persons to be remanded because at that time they were security detainees under the decrees that they have enacted and the detention orders.
Watembo undanga na kito Kenya mendro nga kito nyimbaile nga baile andum baribitu nata fo ye sambari man katu otumo kanto nintankada bunda la mutamole muiti ibeole la karola otumo.
But Mr. Touray, once that case was dismissed, in effect, there was no reason for their detention.
Mr. Touray case ni je case bay dalila taje ko take pour ka o mare ni ka kango di pour kete muta ko take sindit lagile.
No, legally, ugly as it was, there was a basis for their further detention.
Akuli
Under the
akeja uyata
dispensation that was
nyawnyandi.
prevailing at the time.
Ni elua nyina lanya jube wutumo sartolu bekeri no nyaming fereti je foyo kangota puriye sambari man wo mukolu lanya leti wo jamano.
Because the three gentlemen were already detained under the security, the decree number 3,
Kato
the
tumo
state security detention of armed and police personnel decree.
wotumo sartola bunda sabanja ome itelia londi decree number 3 itelu beole la muto kono nung meya lonko wenyin kangoli di kabrim police fo sojarolu mutamolu men ya lonko be mutalawulu kono wol betar lawo sartole kono nung.
I don't necessarily agree with the contents of the decree as it was.
Nte fango de mansong decree nyin kolu menu ba kono mansong ila meta.
And I also do not share the opinion that I do not have power to release them.
Adu nyim fana manke na miro tika foko sembe tentela wotumo pour kebula. Na miro tengoti ningde.
In later cases, people were arrested under the same law and detention, their names were published under detention orders. And I went ahead to grant them bail. My only difficulty was a procedural one. The issue came before the court and it was determined. There was an appeal against it. The High Court affirmed the decision of the lower court. If that procedure had not been followed, I was definitely going to release them.
Amunta kolu belari no nyame wala mnyinti ko. Itelaw kito kola kitido lumenu nata meni yalon ka kita fasongo nyongol leti. Womo lu ninge la kuobo nyoto nte bulale. Yo bari wo tembo telako men wairi atelo mkufolo nyinti wotumo itelwe o kantoni o tankada bunda la kango men koto wala na mebula bari akola kiti kotango lumenu nataje anyongolu ninga olu kito lu kente bulale.
And what decision had the magistrate court made that the High Court had affirmed?
Kanju the magistrate court molan kiti bundan no mu kanju malata me yalonko kiti bumba fanam bulata o sar kankile wala no.
The magistrate court has declined jurisdiction on the basis of the fact that they were arrested and detained under decree number 3, and their names were published as persons who were a security threat to the nation. And because of that, the court declined jurisdiction to say that they cannot be granted bail. And that was the decision that was affirmed by the High Court, that they could not be released under any circumstance.
Kiti bunda ba nying High Court ya kangomen londi. Ya kiti bunda duma kola kangomen londi. Wale nyintiko. Nyimolu decree number 3 imutata o kangole koto. Andu wale nyintiko umolu memme mutata o kango koto itebula nola. Yo bitungo dalilo le ya sabu birintel fana nga ko nyimma ntata nga jibe ko wairi wo sarto le belori teliole londi wala decree number 3 so dalilo le ya sabu imebula no ko lata wala nyama.
So as a lower court, you could not substantially overturn the decision of a superior
That
court.
was the only reason I couldn't overturn the decision of the High Court. But if the matter had not gone before the High Court, and if it was not an issue that was argued and determined by the trial magistrate, I was definitely going to release them.
Ko nyimbe wala nyama katu niaje kitibunda sonta kitibunda ndingula kangola amunta kolu la nyale ya sabu barnatara amanke woti nung tombi ntebe ngela kito kenu nyami tombi mbebula lale. But wotumo kitid bundado nyimfong la kangolondi ko nyanta tamala wale yo sabu.
I would like to pose a question for academic debate. The
Yes.
decrees that were passed,
Bela fa nyininkaro puru nyininkaro jabi. Yenyi decree men ya blondi.
they were ordinary legislation at the time.
O wato lo luwa lo ngolo bekeri ne o wato lo.
Come again?
The decrees that were passed was ordinary legislation. It was ordinary law. They were below the constitution.
Nyimu luwa let men yalonko be luwa bias lumalal.
They did not have constitutional force.
Arungi man sarto so luwa bakoro.
I know that the decrees are now part of the constitution,
Ngalo nyin decree nyin sa ntangi be na constitution luwa ba nyi ba kono le.
but at that time they were not.
Bar o wato la itenda luwa buku ba nyi kono.
Was it constitutional that they were used to suspend provisions of the constitution at that time?
O wato le ke munafa ila la bang nyin kamala ko puru ka bandambili ke ining luwa buku ba tema.
Could they have been legally challenged?
O luwa to mosi akwo nyin isa no masata no la bang fo ya dandula ba.
I don't think they could have been legally challenged at that time because
tembo ngamma mera mosilwa wulindino ulukama purka balang.
the only forum where such a challenge could have been
Mosiwo balambaya wulindino bunda menna
raised would have been in the Supreme Court.
wala bekela nun Supreme Court la bundati.
If I mean the Supreme Court, I mean the last and the third tier.
Ninko Supreme Court wala bunda labango me ya lonko le bunda sabanjanguti kitola karola.
Let me clarify this. We used to have a Supreme Court, but it was just by name. That Supreme Court was the High Court.
Wo nkafale nun Supreme Court bari tole mudrong wo kiti bunda wala High Court kiti sandongo.
We had the Supreme Court and the Court of Appeal.
Na Supreme Court soto bari nga kiti sankam bunda fanan soto Court of Appeal.
The Gambia's last court then was the Privy Council.
Gambia la kiti bunda labango wo tembo ka fujele Privy Council.
The only place where that issue could have been ventilated would have been perhaps the Privy Council.
Wo konyi mosa abonyoto damen ka jaba kese woto wala woto bakela Privy Council letu no wotumo.
But going to the Supreme Court was certainly very expensive.
Bari kata Supreme Court wo tembo wo bakela ku kolengol tinu wotumo adaba abakole ala.
The Court of Appeal at the time exercised jurisdiction on constitutional matters.
Katu kiti sankam bunda nyi wotumo ka kolu menu tamandi wala mu constitutional la kolu velari nyame.
But this was not in relation to matters pertaining to legality of legislations vis-a-vis the Constitution.
Bari wo mantara dendi kol la men ya lon ko lebe dendi lualu la nyala sako kol men ya lon ko letata constitution o nyim fangoma wala mbanko la sarti buko nyi.
The reality we were faced with was that we only had the Constitution just in skeletal form because the most vital parts of the Constitution were suspended.
Ntelunga nyatili nu menna wala mkuko le ngotikatu o tembo Constitution o nying kuku malumenu ba kono ntelisi mensi ntelisembentu ya nungotumo ya ulube bondile nungotumo ya ulutong.
And the status of each and every decree was that insofar as it is inconsistent with any provision of the Constitution, the decrees will prevail and override the Constitution.
Adu wotumo kuwa membe kering wala mnyinti wo decree o lumenu ye londi wonya. Nani constitution wala mlua sarti buku ba banko katanu menna nani wala sarto lu benta daoda constitution nyina ko wala mbanko la sarti buko nyi kawla ko lu landile decree nyina ko lu kawle tamandi kalo wala la.
The decrees were not lawful, if you ask me. They were not lawful, but it was that order that gripped the nation and country was being ruled under that.
Nyinin ka wo decree lu imanke luati de in andu ning lu amanta but bitungo tembo membe kering kamani sembo wala yolu londi wala na ikatama nu wala la.
Mr. Touray, precisely, I just wanted to agree with you there because that was the question I was posing to you because the Constitution at the time was the supreme law of the land. You could not have had lesser legislation which attempted to suspend its provisions. So it was clearly unlawful and it could have been legally challenged, provided obviously that the right circumstances were available, which they were not.
You are perfectly right.
Amonta council kama nyinin kaja wala mnyinti ko na kumnyinin karo fon koto mweleti yemen jabi teng kato tembo wo decree olu bankola loi sarti buko nying asi balanno le wo decree la wala ke bay bari bitum wairi anata findi ko wo decree olu tembo sembo dita wolela ka tambi bankola constitutional fon la lotan kangolu la wo dalilo le asabu.
But the scenario we were faced with is that the son becoming much older than the father. So decrees were, they couldn't have, in a normal setting, by any stretch of imagination, they couldn't override the provisions of the Constitution. But that is the whole idea of a military government.
Wolu malodula soto sembe dula tela taran dula tela niani na constitutional la bar bitum wal nata la nyaming amonda menu be steering menu be mararo bundala wolu yon wal nata o decree olu fisiandi ke sembentu ya ke tambindi bankola constitutional la lotan kamulula.
Thank you very much for that.
Thank you. And then
do you know what eventually happened to them?
They were escorted to Mile 2 prisons, and that was the end of the case.
And
then I think it was the same day I was sacked as a magistrate.
Na mera ate ulun kilung lem fana yente bay kambondi na palaso to ko magistrate.
The following day, I got my letter.
Asomo lem yenna letter odinna.
I was dismissed, and the dismissal was from the Personal Management Office, PMO.
Andu yembay biri letter o nyina tinye aketa ko kaito nying abota do ku bunda lela memmarta banko do kula lu bela ka fujele Personal Management Office wala PMO.
And all it stated is that we have been directed to dismiss you from the service of the Gambia government.
Adun kango membe safari nje wala nyinti ko ye kango le di itolu fanana puri yente bayina do ko to kabon Gambia man sakunda do ku bundala.
So I had to write a petition.
Tunata kaito safe wala mnyama memu kolu sainkan wulindi kaito ti.
I addressed it to the head of the junta, and that's the chairman, Yaya Jammeh.
Nga letero men safe wonya nga ki junta sojar bunda la kuntonkole utumo wala Yaya Jammeh fangoti.
Can you tell us why you wrote directly to the head of the junta instead of addressing your concerns to PMO?
Ne asabu foi sa fono nya dalilo me asabu yele taro nyin safa andu yaki me wala juntan ko la juntan la nyaton kodi imaki me mola me alon ko wala marling Gambia masakunda do gulal be na nyaton ko imaki we.
Now, the following day in the morning, I was called to say that I had a letter. So I went to the High Court, and that was where I received my letter.
Asomo le mi yen kumandi ko nga letter o sotole bitun data High Court wotembo le mi letter o dinna.
I then went to the master, and the master said, "Let's go to the Chief Justice." So
data master kongata Chief Justice ya.
But by this time, it was Omar Al-Ghali who was the Chief Justice.
But wotembo Omar Al-Ghali atelom Chief Justice tinu wotembo.
But he was the one who said, "What happened? It's not right," But there was so much fear in him.
Bari atele nyum fonyen ko menketa anin silo manta amanke kutilindi wuti.
So
bari nak memba kono utumo ate fanambe silandinne utumo.
So he asked me to write a petition. He told the master of the High Court, then Usman Jammeh. He said he asked me to write a petition and give it to the master so that he can look at it to vet it before we forward it to the Office of the President. He expressly said I should write a letter to the Office of the President because, as far as they were concerned, Judicial Service Commission was not involved in it at all.
Kato ate Mr. Al-Ghali atele nata nyin kango fonye purunga letro safe me ya lonko wale munte fanana kumala nyatili nya letro ti petition konsia safe yo baribito ako ninga safe nsa di mastala memmarta kito bundala utumo ka faina Usman Jammeh ni o letro nyin jibe aya yirika utumo isina tentendi kaki president la office odo.
Can you tell us how you were appointed?
Sa fono nya yeta do ko la nyadi.
I was appointed by the Judicial Service Commission, not the PMO.
PMO mandeta do ko la Judicial Service Commission wala mkitindir bundala kafusembe mabati bunda ba nyingole enteta do ko la.
PMO has no authority over my service.
PMO manka wo kanso don tela do ko la karola utumo.
In fact, act of PMO even directing that letter to me is also unconstitutional.
Andu hani PMO la o letro fongoka letro bondi tella karola ka kintea ani sartolu manta nyola.
So, like he advised, he said I should write a petition. I prepared a petition. I brought it to the master, Osman. When he looked at it, the very first paragraph, he laughed.
Why ate ko nga letro safe nte fana na kolu mu menuti nga letro safe petition akonsa di mastala nga di mastala biriwo letro nyinna borindi follow nyin jube dorong ajeletale.
He told me, "Don't you realize we are dealing with a military government?" I said, "But if you ask me to write, I'm just expressing my mind."
Akonyam feta malon ko ini sojar man sakundale betilindi nyola teng ngai ha mambala wala bari nte fana ko membe nsondo mokono nka wala findindi teng.
Sorry, Mr. Touray, can you just give us the contents of the letter in summary?
Letter ro nyin ka sutande don foi sa fono nye kuma kan wol men safeta kono ba.
Would you have a copy of it available?
Letter ro nyin na copy be bulu jande ba.
I don't have it here now. I passed by my office this morning because after the change of government in 2016, I filed an action against the government to get a constitutional declaration that the dismissal and the subsequent termination, because I was dismissed and then thereafter later in 2000, I was also terminated, were unconstitutional. So I went to the office to try to access the file so as to bring a copy along, but I couldn't see it. But I'll get it for the TRRC later.
Yusomanda antambitan na ofiso la puru nyin kamala nsika mbulo sila kaito lukang meya lonko. Nte fango birimman sakunda falinta nun 2016 nata savaro kele kaita ndikolu menu tamata ntela karola menu ni silo manta nyola menu ni sarto manta nyola munta ngasamaniro ke okuotole yo bari bitun lafta mbulo lala no kaito le kamfonsi file nyin soto ba birinna tan na ofiso to nga kata nyawnyandi mang mbulo man lano kaito lukang bari mba kata la ngana fereke ngao kaito lufutandi TRRC ma nyatondo.
Were you able to find your appointment letter or your termination letter?
Ile ba later on you waranto yeta later on men na fo ina na jira bang.
Yes, that's what I am saying. I have them in my case file, personal case file, that in the action that I instituted against the government. I'll make copies available to the commission.
Ambole fokanteng ibebe na o file ole kono na file ba nying yo bari mbe fere kelale mbulo ela o kaito lukang ngesa inka yelema nga fere ke han fo yefuta TRRC ma.
And just out of interest, how did the institution of that suit go?
Puru sulo kan rondong ilo samanero ni safero nying akeno aketa no nyadi le.
The decision went in my favor. The dismissal and the termination were declared unconstitutional. They were, in fact, the angle from which I approached it was that they clearly amounted to an unwarranted interference in the administration of justice.
Bitumbiri ya ko jube ya no masata ndele nataganye akonyi nkono katubiri ya alanya aninkulu Kenya jibe itataje ko yekolu kemnyu nyaming ye tamandinu nyaming anin sarto manta anin lua manta nyola wodalilo le ya sabu ndenata kango soto je menketa to nyati nteganyeta akonyi ndo.
So this provides clear judicial precedent of interference in the judicial system by way of unlawful dismissal.
Munda we me tamlinya wala nyindi ko da bulo keta kitindiro kunyato me ya lonko wala be kanu andu wonata na sababu ila bayro jinto meni luwa manta
alwa keta wala nyam.
Please let's go back to the contents of the letter. I'm particularly interested in what actually made the Master of the High Court Usman Jammeh laugh.
Sila ngata letter on nyinto kuma kama me ya lonko wala be fururu ni letter on nyingono katunga en sula bagal pour ka long mune ya sabu kabri master membe nunje ba fala me Usman Jammeh bringa damra ka letter on nyin karandrong aya borondi folo nyin karandrong a jeleta lefta ka wota lolo.
He was of the opinion that the letter was too radical.
Atela jero munyete ko letter on nyin kuma kan lumenu bije iketa kuma kan bambandi ngolete.
He asked me to rewrite it. I did so. But when I brought it again, he was of the same opinion that it was too radical.
Akona ta fonye nga sa inkan safe nga kangolu do nga kuma kangolu faling. Na ta sa inkan safe nga kuma kangolu faling bare hani o fanang biringa na ta konyen hanimbi ku kilimola bijede.
Do you remember any particular words or phrases you used?
Hakilo samu no yemu kuma kan sifa le keje memba ila mira ro memba sabu atak ba fala ko ila kuma kan nyin chambo warta bagale bambanda bagale.
I can't remember anymore because the two drafts actually remain with him in his office. I'm sure he must have destroyed them. He was the one who finally toned down the letter. And then that was the version that we sent to the office of the president.
Hakilo te wolu mutano la katu kumeri ngolombari nyin kaiti fulolu be ngamen fulo safe nata fulanja o men fanan safe wolu be labanta atele buloko no bari ate fangole nata safer ke afaye ay menki bitun kolu nata wole nyama.
After about 12 days, I was called by the confidential secretary of the Secretary General.
Secretary General.
I went to the office of the president.
State House.
I was given a letter reinstating me back into the service of the judiciary.
Who was the SG at that time?
Well, SG, Secretary General to Warola.
This was Wada.
Do you remember his first name? Was it Mustafa Wada?
Mustafa, yes.
Mustafa Wada.
I remember before they gave me that letter, in the intervening period, he called me to say that I should send a second petition.
Hakilo bakang wo wuche onyin kono janning kumandir flanja ngo bekela wala nyim fanya kongata nga letter flanja ngo safe nyanta menkila.
But when the they sat over the petition. The issue that was raised by the Attorney General then was that I should have committed Mr. Jobate for contempt of court rather than dismissing the case.
Amunta birite lusita ko nyin kunna ya jube iko nyanta Mr. Jobate dundila nun kito nyin kono le ka foko amunta te jututa kiti bunda nyin nale wole fisiata nun nga ko nyin mume o bay.
Did they tell you on what basis you should have cited him for contempt?
Well,
in the course of the arguments from both sides, there were ethical issues which were observed on the side of the prosecution. So part of it filtered in my ruling. That was the reason why they said that I could have adjourned the matter and dealt with the prosecutor by exercise of the powers of contempt rather than striking out or dismissing the matter.
Apart from the Attorney General, who else sat on that petition?
Attorney General,
I believe it was the military council, and the Attorney General was a member of the military council.
And who was
the Attorney General at that time?
This was Mr. Bite Musa. I sent in the second petition explaining why I could not have committed Mr. Jobate for contempt. And after a discussion on that by them, then that was how I was reinstated.
Ngalong ko birital fangol sita ya ko jube kachata akwala inata kamben dalilo kang puruka jeko yenta murundi na doku wokang yenta.
It's interesting because at the beginning you told us that the effect of some of these decrees was that it suspended legislative as well as judicial powers. And in this case, it looks like the council is sitting over your case as an appellate court looking at the merits and demerits of the case.
Nyabo warabaga komando ne yafa mole no njanko ni decree li nyinketa loi len men ya lonko loi la sarti buku ba nyin anin loi kiti bunda nyi na sembo nyi awol be talale silan afere jan juntala mol keta mol de me ya lonko wolle be siri tela ko ibela ko nyin kiti ka mosa fono kiti bunda mul ngona mje fana de betala ko nyin kiti ka.
Yes, that's absolutely true, because the Chief Justice, with all due respect to him, and may I pray for the Almighty to give him, how do I put it, Jannatul Firdaus. But the entire judicial system threw in the towel. They didn't want to take any single decision over the matter.
Kenya jube akonyi mbe menu sita kunto katabula atenyim fangala memu ko kunton kote alama nema ninkafarkelae itelbe na ate bulo kunyin konyin konole imam pare kantaman laje wo tembo ko afindita nu nyami.
So all the power was concentrated in the hands of Jammeh.
Ukato tumo sembo bena tadun jammeda manne bulo kono.
Who was the Chief Justice at the time?
This was Omar Al-Ghali at the time.
Omar Al-Ghali atelom kolu nyaton koti wotembo.
I must also say my sacking was the first interference
by
the executive
in
the judiciary. And it generated a lot of condemnation from the United Nations, from the Commonwealth, so many of these organizations.
United Nations anabunda kotengulu ibeya doya kafoko sojaroli apare sojar mansakunda ye bulobula kitibunda la do kokono.
And I remember it gave Sadauda of blessed memory occasion to condemn the junta He said, now it's clear that we have gotten evidence that the junta is not sincere to whatever they are saying.
Andu wo kamfanan tala alhaji sadauda banko nyatun ka folo alama nema nin kafar kelaye atafanan nata doyaro ke akola ko silanga seneyata le kaitandi molula ko nyi sojarolu ye memfo ko itelube mala nyamin woning itelube ke ka nyamin sayin ifatatale.
So when the dust settled down, I was moved to Mansakonko.
Tumbirin kankango nata tenkun yente saundi en samba Mansakonko.
And before the dust settled down, did anything in particular happen to the then Attorney General who had made some suggestions as to what you should have done in the case?
Janding kankan nyimbe temkunna fo kuna na sotola menketa memmunu Attorney General to wato la menarana fo enyanna kule mentaman la case nyindo fo kuna na kala.
Well, by coincidence, the day I was reinstated was the day he was sacked.
Between kolu benta nyaming. Asike amunta ibentele katu lume yente murundi na do kola luna yate bay do kola.
Was that coincidence or executive plan?
Wo mo kule malo ko bentale bang fo kule me yalon ko abota santo la ferole me yalon ko abota santo.
Well, let me say by coincidence.
Nte sa fono le kolu bentale. Nte si wala fono.
It's strange that it was coincidence if his advice was disregarded, you were reinstated, and then he was booted out.
That's how we saw events.
Yete murundi na yate bay ate min me alon ko yate ate yamaro dinu alaw yamaro nyingi mala yamaro ta sire inata yate bay yete murundi.
Abito de kolu lata wala nyama.
Okay, thank you very much, Mr. Touray. I believe it's now time for the break. We'll just leave it here and then go on to the break and come back. Mr. Chairman, I hand over the witness to you.
Yes, indeed. Coincidence, extraordinary. Thank you, Mr. Touray, and thank you, Council. We will take a coffee break and come back at 12:20.
Thank you, sir.
Adjourned. Thank you.